Good day, everyone. I am Harry, your moderator for this webinar on the behalf of the organizer company called OnlineAudioWebinar. I welcome everyone for today's webinar, which is called Responding to EEOC Discrimination Charges, What's Your Business Case? So now, I would like to introduce our presenter for today, Bob McKenzie. I believe he's my favorite speaker because I have seen his webinar. So let's come with the bio. Bob McKenzie has over 40 years of human resource management experience. So now I would like to hand over the floor back to our speaker. Over to you, Bob.
All right, Harry, thank you very much, and thank you for attending. Areas to be addressed. What we're going to be doing is we're going to take a look at the discrimination charges with the EEOC. We're going to take a look at what the discrimination charge looks like. Reading between the lines, should we hire an attorney? Well, that's a good thing. Talk about non-binding mediation. Then how to outline and prepare your case. What documentation you need. And then if you have to obtain statements from witnesses and our managers. And then I'm going to talk about the importance of work standards and preparing for requests for additional information. Now what I'm going to do is going through some charge statistics. Now here's the charge of discrimination. If you can't log on to the responder or have questions, this is how you get to it. Discriminate, and then here's the other kinds of things that you may want to think about. So what I'm going to do is kind of go over some of the other information. And by the way, it's got to be notarized, okay? Let's take a look at the some of the reading between the lines. If you have done an EEO1 report, typically you don't have to do an EEO1 report if you have less than 100 employees. But if you have a federal contract, you have to do it if you have 50 or more employees. So just something to know. Should you hire an attorney? Well, it depends. It's just an alternative. First couple of cases. Here we are. This is non-binding mediation. This is the charge. It says here that we invite you to participate in the mediation program. All charges include that offer. Mediation process takes about 3 months. Look at the discrimination charge as a risk of doing business. Review any documentation you have. The allegations in the charge I didn't know anything about, but also have others review the position statement. Okay, our findings, dismissal, and notice of rights. It could also be called a right to sue letter. Your private suits rights, and this is what it means by your right to sue. If you want to pursue it, then you must file a charge in federal court within 90 days, okay? And if not, then your statute of limitation is gone. And yeah, I had to work with the lawyers very closely. So just to make sure that you know that, and they do have an attorney referral and assistance. So just to make sure. Now, here's the importance of work standards. Behavioral standards are also important. Things like telling the truth. But the whole idea is very simple. When there's a gap, corrective action is necessary. And when I talk about the importance of documentation, this is something Federal Appeals Court ruled in favor of an employee in an age discrimination case when the company terminated the employee without any documentation. We've had when employer stated motivation for adverse employment decision involves the employee's lack of performance, but there's no supporting documentation, a jury can reasonably infer that the company's reason was discriminatory, but can conclude the employee was terminated in violation of the Age Discrimination and Employment Act. The conclusion is reasonable in light of the complete lack of documentation. Here's some documentation, okay? And what I will tell you about your performance standards, take a look at your performance appraisal. So that's just one thing. So you got the performance appraisal. You've got documentation of the counseling and coaching sessions, accommodation requests, and any disciplinary actions you have, incident reports, okay? Harassment, discrimination complaint, investigation reports, attendance records are all important things, okay? Termination reports. If you need to get notarized statements, read the statement very carefully, make the changes, make the corrections before signing in the presence of a notary. But make sure you have a reasonable amount of time to get the information. If you don't, then ask for the extension. Here's the thing, dealing with an investigator, always be polite, never argue with the investigator. I follow up very quickly to any emails or telephone calls they make. Summary, and this is really your action item. If you receive a discrimination card, a charge, tell your boss, okay, you've got a discrimination charge. Sometimes it'll come from your boss, okay. And just remember, it's the employee's right to file a charge of discrimination. And there's no cost to them, and it's simply that risk of doing business. Read through the charge, read through it again, make a copy of it, scribble notes on the copy, do whatever it has to do, think through your response, and start your developing your response strategy. Keep the faith. First of all, thank you for attending. Number one. Number two, don't worry. I mean, if you get a discrimination, first of all, you got to make sure you do things correctly, okay? That you're consistent, you're treating individuals with respect and dignity. Enjoy the rest of your summer. There's not much left. Thanks.
Hey, Bob. Thank you so much. Thanks, Bob. Thank you, participants. With this, we conclude the session for today. Thank you so much for joining today's webinar. Have a great day.
All right, you too.